Thank you kindly, Chairman Issa. I appreciate that, and welcome Judge St. Eve and Judge Scudder. The hearing is on fiscal responsibility in the courts, which makes matters pretty simple for me. We should make sure we give the federal courts all the resources that you need to carry out your constitutional duties without having to fear for the safety of your judges or their families, court personnel, and members of the public who are in federal courthouses. We should thus set a legislative record today about the needs of the judicial branch. We should not attempt to see if Congress can use our power of the purse to coerce judges into ruling this way or that way on a particular case. That's an attack on judicial independence, the power of the courts to say what the law is, as the court put it in Marbury versus Madison in 1803. Funding is essential to the independence of the courts. Hamilton began Federalist 79 by acknowledging this relationship. Quote, next to permanency in office, nothing can contribute more to the independence of the judges than a fixed provision for their support, he said. In the general course of human nature, a power over a man's subsistence amounts to a power over his will. Alas, power over the judicial will is exactly what President Trump has sought since he took office. Judges who decide in his favor are brilliant, faithful judges, and those who decide against him are communist, radical left judges, even if they were appointed by a fellow Republican president. In March, Trump called for the impeachment of a federal judge who ruled against his administration on a fundamental constitutional question, a judge who had been nominated to the bench first by President George W. Bush. Quote, this judge, like many of the crooked judges I'm forced to appear before, should be impeached, Trump posted on social media. Meanwhile, his allies in Congress have repeatedly fought to change the way that the courts work just to benefit him personally and his administration, such as when they tried to make all state cases against him and his associates removable to federal court and to prevent judges from being able to issue injunctions that apply beyond the specific parties to a case. And last month, this committee passed a provision stripping the power of judicial contempt in certain cases that would allow Trump to ignore adverse federal court decisions, even though 8 in 10 Americans think the president should have to obey the orders of the courts. And that is indeed the whole premise of judicial review, as articulated in Marbury versus Madison in 1803. But the MAGA siege on the judicial branch has not just been limited to anti-judicial legislation. Every major resource the courts need to act as an independent branch of government is less achievable because of Trump's program. Trump's ad hominem rhetoric against individual judges has helped fuel an increase in threats to judicial security. His lieutenants at DOJ have sharply limited the buildings available to the judiciary, even as our courthouses are falling apart. American cybersecurity, including our court IT systems, is weaker under Trump after he neutered the sub-agency within the Homeland Security Department responsible for keeping us secure from online attack. And Republican leadership took a bipartisan deal to get the judiciary more federal judges and then twisted it to their own ends. And I'm exempting here my friend Mr. Issa from that description. Some of our colleagues have suggested the only way the judiciary will get the funding it needs is if judges change how they rule on decisions important to Trump. Punchbowl News recently reported about the controversy over threats to judges. When asked about increased funding for judicial security in light of the skyrocketing threats to federal judges, my friend Chairman Jordan told a reporter, I don't know that there's going to be a lot of people excited about giving them an increase. Another colleague reportedly suggested the judiciary, quote, should stop screwing everything up if they want more security funding. Checks and balances only work under the Constitution when the three branches of our government respect each other's essential independence of action and decision. To withhold the means of guaranteeing the safety of a judge or their family is to compromise that independence. A judge who receives deliveries at her home reminding her that the people threatening her online know where she and her children live may be less able to think clearly and rule objectively on the merits of a case if they fear that their family's in danger. And that's not an academic point, but an urgently practical one. Threats to federal judges skyrocketed over the last 6 months as President Trump escalated his personal threats and rhetoric against federal judges and courts. According to the U.S. Marshal Service, 197 judges were threatened from early March to late May this year, more than double the number of judges that had been threatened in the prior 5 months. Judicial security should not and has never should not be and has never been a partisan issue. When Justice Kavanaugh was targeted in 2022, Chairman Jordan rightly said, "We don't want any violence here, but let's not have a double standard." And I agree with that. We must oppose all violence and all threats of violence against the federal judiciary from whatever quarter they arise. We must give judicial branch institutions all the security funding they need, wholly without regard to which judges are being protected and which cases they may be handling. Political control over judges is a hallmark of monarchical and authoritarian regimes. Indeed, King George's attacks on judicial independence were part of the Bill of Particulars set forth in complaint against him by Thomas Jefferson in the Declaration of Independence. Quote, "He has made judges dependent on his will alone for the tenure of their offices and the amount and the payment of their salaries," Jefferson wrote. It would be a dangerous breach of our constitutional values to withhold critical security funding for the judiciary in an effort to change the way judges decide their cases. I'm certain that we cannot and we will not do that today. I look forward to hearing from our witnesses, and I yield back to you, Mr. Chairman, the remainder of my time.